Good morning. Today let us discuss about the introduction of commercial law. Commercial law is also known as business law, merchandise law, trade law. Depending on jurisdiction is the body of law that applies. So it can be derived as business law, or else it can be called as merchandise law. Even it is called as a trade law. It is nothing but the government is offers a law, so all the business people have to follow this law. Commercial law governs commercial transactions and business dealings. So regarding all commercial activities, it is governing. It aims to facilitate commerce by upholding agreements. So with the help of agreements, it is facilitating the commerce. It aims to facilitate commerce by upholding agreements. So the same thing is with the help of agreements, the commerce activity has been done properly. So now let us focus on the importance of commercial law. So it provides a stable framework for business. So ensures fair competitions and ethical conduct, protects investors, businesses, and consumers, facilitates the flow of goods and services. In general, all the activities of the trade is done in a proper manner. So based on the law, so it gives a proper framework for the business. It helps for the competitors. It helps for the customers. So both the buyer and sellers will be satisfied with the help of commercial law. So now let us focus on the elements of commercial law. So commercial law governs business transaction, focuses on elements, contracts, sales of goods, agency, intellectual property, finance or banking, and consumer protections. Importance of contract. A contract is a legal enforceable agreement where a parties promise to do something. So it is a legal protection. So clarity and transparency, risk management, evidence and reference, economic growth, compliance. So it is nothing but both the buyers and sellers have to follow the rules and regulations. It comes under the rules. It is a written document. So both the needs. So what is the buyer's needs and the seller's needs, it will be written in a document. So it will be a clarity. So what is there in the document, what is there in the contract is clarity for both the parties. So definitely it is considered as a risk management. So it can be called as an evidence also. So it helps to develop the economic growth. Elements of contract. So offers, acceptance, considerations, legally competent parties, meeting of the minds, terms of the contract, legally of the purpose. Is nothing but the seller has to offer, either in the two parties, the one party will be offering, and the opponent party has to accept. And for both the people, it should be a consideration. Consideration is nothing but so both the parties has to be satisfied, both the needs and money, and a legally competent parties. So it is always in the legal meeting of the mind. So what is there in the mind? It will be in a written terms of the contract. So based on the terms, the contract differs, and legality of the purpose. So whatever the terms and condition, so it is coming under the rules and regulations. So a contract has to follow these things. It is one of the major elements. Each and every contract have to follow the same thing. So offer, acceptance, considerations, legally competent parties, a meeting of the minds, and terms of the contract, legality of the purpose. While drafting the contract, both the parties should be in a proper mindset. So proper mindset in the sense either one or another people can be mentally challenged. In that case, this contract won't be accepted. So that is also considered. And both the parties in a contract has to be satisfied. So if it is a business in the sense, so he should be satisfied with the commodity, and the opponent party should be satisfied in the money. So it is a proof, and both the parties can consider it as a proof. So what is there in the contract has to be followed strictly, and it is coming under the rules and regulations. Either one people can ignore the contract. In that sense,